So now we're going to talk about disputing coerced credit card debt with the original creditor. So again, this is if it is still being pursued by the bank that issued the credit card. So it wouldn't be a debt collection notice, a debt collection letter, but it would be a statement that the survivor receives or maybe does not receive. If they didn't take it out, didn't know about it, and they've subsequently moved, they may never have seen a statement or gotten a statement. They may only have discovered about the credit card debt through the credit report. It's also possible to use this remedy that I'm going to discuss for debt that was coerced for an existing credit card account. So if the survivor had a credit card account, with Wells Fargo, and then the abuser used it without her knowledge or permission, then the survivor will be able to dispute those charges as well. So the law that applies to credit cards, the federal law that applies to credit card is the Truth in Lending Act. And then there's a specific provision of the Truth in Lending Act called the Fair Credit Billing Act. And the reason I mention both is because there's two different mechanisms. TILA is the broader law, and it doesn't just govern credit cards, it governs other types of credit as well. So like mortgages and auto loans and other types of financing. But it also covers open-end credit, which is what credit card is. So there's TILA, and then there's a general unauthorized use provision of TILA that you can use, or the Fair Credit Billing Act and billing errors, and there's those provisions that you can use. And I'll go through both of them to explain how they're different and how they can be used. The phrase that is used in TILA is not identity theft, but it's unauthorized use. It's either an unauthorized account or unauthorized charges. And I will, again, in the following slides, define what those are under the statute. So it is narrower than the definition of identity theft under Texas. So for some coerced debt survivors that were just coerced into these transactions, they will not be able to use the provisions of TILA to dispute those charges or those accounts. It really will only be for those that were unauthorized. And again, I'll explain what those are in the next slides. The law does require, similar to the FCRA, an investigation and notice of the results. They can't just say, sorry, it's not unauthorized because you were married to this person or you were in a romantic relationship. And I'll explain in some more what the investigation actually requires. So as I mentioned, there's these two parts that can be used. The Fair Credit Billing Act, which is found here in 15 U.S.C. 1631 at SEC, or the more general provision, which is 1643. So again, the billing error, that's what we call the Fair Credit Billing Act, governs billing errors. So this is, that you can dispute credit card unauthorized use under the billing error procedure. There are 6 different billing errors that are defined under the statute, but we really will only be focusing on this one, which, as you see here, is a reflection on a statement of an extension of credit which was not made to the obligor, or if made, was not in the amount reflected on such statement. So this is what you would be using, saying, I did not, it was not made by me, right? I did not purchase this, whatever. I did not make these charges. That is what you would be disputing. You can also, a billing error, you can dispute just one charge or several charges or the entire account. But with the billing error procedure, as I'll talk to in the next statement, it is very strict on how you dispute and when you notify of the dispute. So it is very narrow, not just in the definition, but also in its application. And then if you see here, Regulation Z is the regulation that implements the Truth in Lending Act. And so if you see here, the interpretation of Regulation Z, or I'm sorry, the provision of Regulation Z pertinent to B1 that I just mentioned defines it as a reflection on or with a periodic statement of an extension of credit that is not made to the consumer or to a person who has actual, implied, or apparent authority to use the consumer's credit card or open-end credit plan. The reason I mention this and the reason it matters is if this was, it hinges on whether the abuser had actual, implied, or apparent authority. And why I say that is because often you can have an authorized user on a credit account. And so if the abuser was an authorized user, even though she didn't make the purchases and he did, even if she didn't know about it, if he was an authorized user on the account, then she won't be able to use this provision because he was an authorized user and he had authority to use the credit card. So here's the part of the billing error procedure that is pretty strict. You have to send the dispute within 60 days of the first bill or statement that contains the error. So it has to be not just does it have to be within 60 days, but it also has to be in writing. And it also has to be in writing at the billing error dispute address. So it is generally on a statement. On the back of the statement, it'll say for billing errors, and then it'll have an address. And that is the only address you can use. You can't use a general address. You can't do it over the phone. It has to be in writing. It has to be within 60 days of the first statement that has the unauthorized use, and it has to be sent to that address. Once they receive that, they have to acknowledge receipt of the dispute within 30 days. So that's not when their investigation concludes. It's just them saying, hey, I got your dispute. Cool, within 30 days. And then they have up until 90 days to finish the investigation. And then after the investigation, they either remove the charges or conclude it's still owed, and they have to give you the results and all of that. So what do you include in the letter? It doesn't have to be any particular format, doesn't have to have any magic words, but it does have to have enough information for them to be able to actually investigate it. So that includes, the consumer's name and account number. The challenge here, as I mentioned before, is the consumer might have never received a statement. And if they didn't receive a statement, it's kind of hard because it's like within 60 days of the statement. You can still do this and say, I've never received a statement. I found out about this through my credit report. These upon information and belief, here's the account number. Usually on the credit report, it's truncated, so you don't have the full account number. You either have the last 4 or the first 6 or the first 8. You may only have what you have. So as a result, you give your name and the survivor's name and social security number, along with whatever account information you may have. And then you have to say why it contains a billing error and the amount of that error. So saying like, I didn't authorize this account at all. I didn't open it at all. It's not mine. The whole, I'm disputing the whole thing, including all of the charges. And then the reasons, right? Saying I'm a victim of identity theft. Here's a copy of my FTC report or my ID theft report, the police report, whatever it may be. They also can and should request copies of whatever evidence the creditor uses to make the decision after the investigation. And the reason that's important is, again, if the survivor never had any statements, never had the account agreement, never had any of that, you want to have that to be able to use if you're going to apply for a 521, because you want to have the full account number. You want to have all of that information. If the survivor is refusing to pay it because it's not theirs, the charges aren't theirs, then the letter should also say that they're withholding that amount. What else do you include with the letter? Again, they're not required to provide an affidavit or police report, but if you have the ID theft report, whether it's the FTC report or the police report or anything else, I would include that. In practice, even when you've complied with all of this, I have often found that they will send a response letter within the 30 days saying, hey, we got your dispute, and also we want more information. Please fill out this affidavit, or please fill out this form, and it'll have a bunch of questions. And it's extremely frustrating because all of their questions are contained in your letter or in your police report or in if your FTC identity theft report, like you have all of that, and yet they're still asking you to fill out additional information. Now, whether that's reasonable or not is subject to finding a fact by a court. And so I would, even though it's frustrating and in theory under the law, you shouldn't have to do that. I would say, please do go ahead and tell the survivor, hey, you may be getting this. Please fill it out. Please send it back. Again, as I sent here, had to be to the correct address, the billing errors address. And so, even if whatever affidavit they get, send it back there, send it by certified mail, return receipt requested, because that starts triggering all of the dates. If they receive it, May 1st, then 30 days from May 1st is when they have to tell you they received it and ask for any additional information. And then 90 days from May 1st is when they have to conclude their investigation. Once the dispute is sent, the survivor can withhold the payments or the amount of dispute, or they can continue to pay it, but tell them that they're going to be seeking a refund without waiving any of their rights. So, it waives some other rights, which I'm not going to get into, but it doesn't waive their billing error rights, like the right to do the dispute. To do the investigation and give them notice of the investigation. They cannot, while the dispute is pending and the investigation is pending, they cannot subsequently impose a finance charge on the disputed amount if it turns out there's no billing error. So they can't penalize them because you're not paying it, you're disputing it, and you're waiting those 90 days. They can't say, well, now you owe it, and now pay us all this interest, right? They can't do that. They can't attempt to collect the amount that's in dispute until the investigation is resolved, but they can reduce the credit limit. So if you have a $5,000 credit limit on the account and you're disputing $2,000 and they're like, well, I'm going to reduce the amount of their credit limit to $3,000 instead. And then if there's any undisputed amount, they can continue to collect on that. There's also some, other provisions about this, about how they're supposed to report it. So they do, on a credit report, it has to be reported as in dispute. They have to notify the consumer reporting agencies of that, and they can't report anything delinquent or negative that's in dispute. So again, if it's like, if there's $1,000 worth of charges on the account, $500 are what you're disputing as unauthorized. If the other $500 is delinquent, they can report that amount as delinquent, but not the disputed $500 that they're investigating. So for the most part, I think most of my clients were disputing the entire account, so we didn't have to think through that. But if it's an account that existed and then had some charges to it that were unauthorized, then you'd have to think through some of those pieces. Whenever that happened to my client, it usually was that the account was in, zero balance, and then it was used. So again, there wasn't this challenge with what's in dispute, what's not, what's being collected, what's not. But just so you know that that's what the law says. So that's all for the billing error under the Fair Credit Billing Act. But what happens if your client doesn't find out about that within 60 days? Maybe it's a month, maybe it's 6 months from when the account was opened, or maybe it's 2 years from when the account was opened, and so they didn't know about it at all. Then there's another provision of the Truth in Lending Act that you can use. It's their general provision on unauthorized use. It doesn't have a time limit. It doesn't have to be in writing. It doesn't have to be at a particular address. You can dispute the whole account or just the charges. Even though you can do it over the phone, which is mostly what we did with our clients, is we'd have them dispute it over the phone initially, then we'd follow up in writing by certified mail, return receipt requested. And there's no requirement as to where that goes, like what address it goes to, or timing or form. I often would send it to the billing errors address as well as to whatever address was on the website, or maybe even what's on the credit report. I would just send it to as many people as I could. even though that's not a requirement, just to show that she didn't, that the client did in fact dispute it. Because if you're doing it over the phone, sometimes you don't have that proof. And so we would have, send it to multiple locations. Once the notice is given, the liability for the unauthorized use is frozen at the amount of the unauthorized use, or $50, whichever is less. And so, and there's certain things they can only do that, impose that $50 if certain things are in place, which, I don't have to get into, but generally it's if they provided a means for use by identifying the consumer, right? Like if the merchant required like a signature that was on the back of the card, or a photo ID, if those things were imposed, then they could hold them liable for the $50, but they can't if it was done online, or in a way that didn't require verification of identity. It's rare. I've never seen in a case of true unauthorized use. I've never had a client where they impose a $50, because if it was identity theft, the whole thing was identity theft. But note that provision is there. So now the definition of an unauthorized use here is a little different. When I talked through the billing error provision definition, it was like the actual implied authority, all of that. This one is and it talked about like any charge that was made. This is a little different. So this says it's the use of a credit card by a person other than the cardholder, who does not have actual, implied, or apparent authority, and from which the cardholder received no benefit. So this last bolded phrase, which the cardholder received no benefit, has caused some heartache to some practitioners, because again, if it was the whole, the whole account was opened without the survivor's knowledge or permission, but then the abuser used it to purchase household goods that the consumer benefited from, right? So food, gas, TV, couch, clothes, then they wouldn't be able to use this provision. Even if they didn't want it, they wouldn't have wanted it, they wouldn't have, wanted to pay for it. If they still benefited from it, they can't use this provision. Again, there's this phrase of actual, implied, or apparent authority. So it's a matter of state law, but there is an example that the regulation Reg Z provides. So it's includes, but not limited to, a transaction initiated by a person who has obtained the credit card from the consumer through fraud or robbery. So that would encompass that fraud piece of the coerced debt. Now, the coercion, it is unclear. Again, you'd have to look at your state law to see if there was actual, implied, or apparent authority. So if, for example, the survivor and the abuser are somewhere where an example would be if the survivor and abuser in a relationship, he like forces her, threatens her, requires her to give him the card, and then he has the card that he goes and then makes a purchase somewhere. The question would be whether at the time he made that purchase with her card, the merchant or whoever had any reason to believe that the abuser had authority, whether implied, actual, or apparent. And that's a fact question. And so, there may be the ability to dispute coercion in that scenario, because it would really hinge on whether they had authority or not. If they were added as an authorized user through coercion, again, because they're an authorized user on the account, then you're not going to have any remedy. They were authorized even if the authorization was obtained through coercion. So again, kind of summary, talking about this, how do you evaluate whether the coerced debt meets the unauthorized use definition? Did they have actual, implied, or apparent authority? And what did the survivor do to indicate that authority? Did the survivor receive a benefit? So again, using the scenario of James and Maria, James forced Maria to open a credit card in her name for his use. When he uses it for a large purchase without her consent and without her being present, he tells the cashier it's his wife's card and he can sign for her. Does he have implied authority to use the card? So we know he doesn't have, actual authority because his name is not on the card, but does he have implied authority? Is that sufficient enough? Does he have apparent authority? And so again, this is all kind of state law, doing some research to see how other cases have come out. Could the cashier and did they reasonably rely on the words or conduct of James? And did the survivor benefit from this purchase? So here's some case law on it. It is, there's the one here from Texas. It's an older case. It was Dillard's credit card. And here it was, I believe in this case, it was the husband of a wife who was disputing it. And they said, sorry, you're responsible for this. And it was essentially, they found that he was responsible just because he was married to the person. And so the decision is like, no, that's not enough. That's not a reasonable investigation. You can't just say you were married and that's why you're responsible for it. You actually have to show that that person used it and authorized it, et cetera. And then you have some other cases here. In the lumber case, I believe that it was the boyfriend of the card holder who went to this lumber store to make purchases. And there, they were like, no, just because you're in a relationship doesn't mean that the girlfriend allowed you to use the card and that there was, authority there. So you can take a look at those. Some practical tips for the unauthorized use provision. Because unauthorized use under the general provision is also a billing error, they have to do the same thing. They have to conduct a reasonable investigation, even if they didn't, send the notice within 60 days in writing and comply with all the billing errors procedure. The creditor still must do an investigation, and the resolution is the same. They have 90 days to investigate and provide the outcome along with any documents requested, and they can't charge interest on those disputed transactions.